any case in a state court that could have been brought by the plaintiff in federal court is subject to removal jurisdiction by the defendant. That means that the defendant has the right to pull the case out of state court and bring it into federal court. But note that removal jurisdiction exists only if the plaintiff could have brought it originally in federal court. If the plaintiff makes a bunch of state law claims but no federal claims, and the defendant offers a bunch of federal defenses, the federal defenses are not going to create removal jurisdiction. The reason is you look at the complaint, there are no federal claims in the complaint, there's no removal jurisdiction. When assessing removal, you first have to consider all of the regular jurisdictional issues as if the plaintiff wanted to originally file in federal court. That means you're going to look at personal jurisdiction, venue, convenience, and the other related matters of subject matter jurisdiction. The statute, 28 U.S.C. 1441, adds additional considerations. Here are two that come out of that statute. One, if it is a diversity case, in any of the defendants is a citizen of the state in which the case was brought, removal is not possible. For example, Mike, a citizen of Florida, sues Jack, a citizen of Georgia, in Georgia state court. That is the state court of the defendant. The defendant no longer has the ability to remove the case to Georgia federal court. Two, if there are multiple defendants, all defendants have to agree on the topic of removal. If there's a dispute among them, that is, there's 15 defendants and one of the defendants does not want to remove to federal court, those who want to stay in state court, in that case, the one who wants to stay in state court is going to win. Removal is the privilege of the defendants and the defendants alone. If the plaintiff files in state court and suddenly regrets his decision, now wants to be in federal court, he has to try to get the case dismissed and then refile in federal court if it's not too late to do so. We'll discuss the rules relating to voluntary dismissal in federal court when we get to pleading. The state court rules might be different, but if they're relevant to your first year law course, your professor is going to teach them to you. In any event, that's the only way out. Assuming that dismissal is possible, that if the plaintiff has to get the case dismissed and start over in federal court, removal by the plaintiff is not an option. What happens if a bunch of additional third parties are added through joinder or intervention? Can those third parties seek removal to federal court? The answer generally is no. Those third parties are going to be stuck in the state court proceedings against their will. There are some exceptions to that general rule, but you're probably not going to get that far into the weeds in your first year law course. As a technical note, if the defendant files the notice of removal directly with the federal court, he also files a notice with the state court. But the point is he goes directly to the federal court on his own and seeks their jurisdiction. The federal court then has to consider whether removal is proper. If so, if the federal court decides that removal is proper, the federal court keeps the case and the state court is shut out. The state court basically has no say in what happens after the time that the defendant decides that he wants removal jurisdiction. So what's the explanation for all of these rules? There isn't a great answer other than to say that there are a lot of competing policies here, and the rules governing removal are nothing more than an awkward compromise, trying to reach a compromised position with relation to all of the rules. While I can't explain removal in a way that will make it all come together for you, I think there are some interesting competing policy justifications that if you think about will help you consider removal jurisdiction. They are, one, the general interest in allowing the plaintiff to remain master over his case. Remember, that's a general principle that persists throughout civil procedure. The plaintiff is the master of the litigation, and we want to preserve that. Number two, the interest in allowing defendants to take their cases within the federal jurisdiction to a federal court to have a federal court consider those claims, those cases. Number three, not to let third parties take over case management and to completely manipulate the litigation. Number four, we don't want issues and cases to be split between federal and state courts where we can avoid it. We want to get all into the state court or all into the federal court and not have them split between the two bodies. And number five, general interest in federalism and deference to state authority inspire us to use removal sparingly. And that probably inspires a lot of the rules that seem to create strange limits on removal jurisdiction. There's an interest in protecting states' rights and the rights of state courts to hear disputes that were filed in them properly. We want to preserve them.